In the fall of 1956, Dorothy Lee Bolden left her house on the west side of Atlanta before the sun came up. She was 33 years old. She had been cleaning other people's houses since she was 9. She walked to the bus stop in the dark, rode across the city through the white neighborhoods where she worked, and arrived at a back door, not a front door, by 7 in the morning. Inside, a family was waking up. Breakfast needed to be made. Children were waiting to be dressed. By the time the woman of the house came downstairs, Dorothy had already been working for an hour. She wouldn't be paid for that hour. She wouldn't be paid for a lot of hours. Because in 1956, the law said she didn't have to be. This is a reality that runs through every part of this story. A legal structure built specifically to exclude black domestic workers from every protection that other American workers took for granted. Some of those exclusions were written into federal law. Some were built into employer expectations. Some were invented on the go, one household at a time, and handed down through a system so informal it left no paper trail. Dorothy Bolden knew all three kinds, and she would spend the rest of her life doing something about it. But that comes later. First, the rules. In most of the households where black domestic workers were employed in the 1950s, there was a back door, sometimes a side door, occasionally a separate entrance entirely, built into the kitchen wing of the house and used by no one else. You used that door every day, regardless of the weather, regardless of what your arms were carrying, regardless of how long you had worked for this family. This wasn't written into a contract. It didn't need to be. It was understood the way the address was understood. It was part of the job before the job was ever offered to you. In Atlanta, in Memphis, in Baltimore, in Philadelphia, in the northern cities, you came in the back. The front door was not for you. What the back door did, what it was designed to do, was establish the terms of the relationship before a single word was exchanged. You entered through the part of the house reserved for deliveries, for service, for utilities. That was what you were. Knowing this was the rule, and following it without complaints, was the first condition of keeping the job. In most households, the domestic worker was left alone with the children for large portions of the day. She fed them, bathed them, walked them to school, met them on the way home, settled their arguments and comforted them when they cried. She was, in every practical sense, raising them. What she was not, by the terms of an agreement that was never spoken aloud, was their authority figure. You could redirect, you could distract, you could produce a snack at the right moment with the practiced timing of a woman who had learned to read a child's mood, like weather. But you did not raise your voice. You did not issue consequences. And you did not, under any circumstances, put your hands on a white child in correction. The line between care and authority was invisible and absolute. Women who crossed it, who reacted to a tantrum or a cruelty the way they might with their own children, faced consequences not from the child, but from the mother, who returned home to find that the worker had overstepped. The worker's relationship with the family ended. What made this rule particularly precise? It was enforced retroactively. You didn't find out you had violated it until after you already had. Under the Fair Labor Standards Act of 1938, American workers earned overtime pay when they worked more than 40 hours in a week. Domestic workers were explicitly excluded from the act. The exclusion was not an oversight. It was written by Congress under pressure from Southern legislators who wanted to ensure that the household labor economy, built almost entirely on the labor of black women, would not be touched by federal wage protections. The result was a workday with no legal floor and no legal ceiling. You left when the work was done, not when the clock said you could. If a dinner party ran long, you stayed until it was over. If a guest came in from out of town and the household routine shifted, you shifted with it. The concept of overtime did not exist inside these four walls, and you did not ask when you were leaving. Asking communicated that you had somewhere else to be, that your time, when not in this house, belonged to you. The rule was that it did not. You were there until you weren't needed. The schedule was theirs to determine. Every domestic worker who worked in a live-in arrangement understood this even more acutely. When your bedroom was in the employer's home, the workday had no edges at all. This one is not comfortable to say plainly, so it will be said plainly. In a large number of mid-century American households, a black domestic worker was called by whatever name her employer chose. If the employer had employed a previous worker named Mary and found it more convenient not to learn a new name, the new worker became Mary. If the employer's children had difficulty with a name, the name was changed. If the employer simply preferred a different name, something shorter, something more familiar, the worker's actual name was set aside. This was not universal. Some employers learned names, used them, and expected their children to use them. This behavior was real. It happened enough that it was a known risk, something a new worker might be warned about in advance by the woman who referred her to the job. What the domestic worker did not do, in most cases, was correct the employer. She answered to the name she was given. She knew her own name. She knew why it was being taken. And she understood, as clearly as she understood anything, that the power to name her was one of the powers this job transferred without asking. Every woman doing this work in the 1950s was a person who had a life outside that house. She had children, she had a husband, or didn't. She had a sick mother, a landlord dispute, a church committee she was leading, and a daughter whose school was about to be affected by a court decision she had been watching for months. She had financial anxiety that most of her employers could not have understood, because domestic workers were excluded from Social Security coverage until 1950. And even after that, the paperwork depended on employers who didn't always cooperate. None of this crossed the threshold. The household into which she walked each morning required a particular presentation: steady, pleasant, untroubled. If her eyes were red from crying, she fixed them before she arrived. If she had slept badly, she would arrive awake. If she was frightened, she arrived calm. This was not a weakness. It was the requirement for access. An employer who sensed disruption, who perceived a worker as distracted or burdened or emotionally present in a way that pulled her out of the room, had grounds, unspoken, never legally defined, but grounds, to end the arrangement. The job required her to be beside herself. The domestic workers, who found ways to carry that weight without letting it show, who could compartmentalize across the bus ride and the back door and the first hour of the morning, are the reason so many families told their children, decades later, that their housekeeper was like family. The first 6 rules were about structure: the back door, the hours, the name, the face you wore in someone else's home. Every one of them was enforced by the job itself. Misstep, and the job ended, quietly, with no paperwork and no recourse, because there was no legal structure on which a domestic worker could file a complaint. But if you're thinking that means the second half of this list is where things get easier, stay with me. Because what comes next isn't structure. It's the layer underneath the structure. The things no employer ever said out loud and no worker could prove were said, but that shaped the conditions of the job as completely as any rule that had ever been written down. If you haven't subscribed yet, now is the time, because the next 4 rules are where the real work happens, and this is the part of the story most people have never heard. A domestic worker arriving at a new household was expected to be competent from the first day, not to need orientation, not to ask where things were kept, what the expectation meant in practice. The first week, sometimes the first month, involved a quiet process of discovery. Where does the good china live? Which burner runs hot? Where does this family keep the iron? When the laundry comes out of the wash, does it go through the wringer, or is there a gas dryer? Which child has allergies? What is the husband's schedule on Wednesdays? None of this was briefed. It was observed and retained. You moved through the house learning it without appearing to be learning it, because appearing to be learning it implied that you were not already competent. The domestic workers who were most valued were the ones who were invisible in their learning, who made their adjustment to a new household look like a seamless extension of expertise they already carried. Women traded this information in the ways available to them, in church basements, at bus stops, through the referral networks that were the actual infrastructure of domestic employment. If you were going to work for a particular family, another woman who had worked there before would, if she could reach you, tell you what the first week required. This network was not written down anywhere. It was more reliable than anything that was. By the mid-20th century, many domestic workers wore a uniform, a dark dress, often navy or black, with a white apron, sometimes a cap. The specifics varied by employer and by region, but the general form was consistent enough to function as a visual code. The uniform was frequently provided by the employer and remained the employer's property. The worker wore it while in the house, and changed out of it before leaving, returning it to its place rather than taking it home. Some employers felt strongly enough about this to inspect it on departure. The uniform was not yours. Neither, by extension, was the presentation it created. What the uniform accomplished from the employer's perspective was clear and consistent. It marked the domestic worker as a worker rather than as a person who happened to be in the house. It removed the visual complexity of her own clothing. What she wore communicated taste, personality, individuality. The uniform replaced all of that with a function. What the domestic worker did with the uniform was something the employer rarely recognized. She maintained it. She pressed it. She wore it with a precision that converted it, regardless of what it was intended to mean, into a standard she set for herself. The same impulse that sent a woman to church in her finest, the Sunday best impulse, ran through how she wore a uniform that was not even hers. The dignity was not in the garment. It was in what she brought to the garment. The employer issued it. She decided what it meant. Wages for domestic workers in the 1950s were not set by law, not regulated by any government body, and not covered by collective bargaining. Domestic workers were excluded from the National Labour Relations Act of 1935, as explicitly as they were excluded from the Fair Labour Standards Act. Wages were set by the local market, which meant what a neighbouring family was paying passed through the same referral networks that moved every other piece of information in this world. A woman arriving to discuss employment at a new household was negotiating from an informal but real position of market knowledge. She knew the range, what the work was worth in that neighbourhood, in that season, for a household of that size. And she went into that conversation knowing that the first number offered would be too low, that accepting the first number was a mistake, and that the conversation needed to happen at the door rather than inside the house, because once you were inside, the geography had shifted and the leverage had shifted with it. The person who opened the back door was usually not the decision maker. A skilled domestic worker learned to make her case calmly at the threshold before committing to step all the way in. She named her rate. She held it briefly. She read the response. Dorothy Lee Bolden did this for years before she understood that what she was doing, what every woman in this trade was doing, was collective bargaining without a union. A domestic worker spent her days inside the private life of another family. She heard arguments. She saw financial anxiety in the way the pantry was stocked differently in January than in November. She noticed when a particular piece of jewellery stopped appearing on the dresser. She knew when one of the children was struggling at school before the parents had found a way to discuss it with each other. She knew things about this family that the family's closest friends did not know, because the family's closest friends had not been in the room. The rule was absolute. None of it left the house. This was enforced by the employment relationship. A domestic worker found to have spoken about the household's private affairs was dismissed, and that dismissal travelled through the same referral networks the workers themselves relied on. A reputation for discretion was the most valuable professional asset she could hold. What no employer in this era has stopped to consider, or perhaps considered and set aside, is what it costs a person to carry that kind of knowledge in isolation. The domestic worker was trusted completely with the family's interior life. She knew what she knew. She kept it. She went home at the end of the day and said nothing, saying it would always cost more than keeping it. There is a word for that kind of trust that flows entirely in one direction. The word is not partnership. Here is what the rule was. You did this work alone. You negotiated alone. You protected their secrets alone. You learned the house alone. You wore the name they gave you, arrived at the door they pointed you to, and left when they decided the day was over, alone with no union, no contract, no federal minimum wage, no overtime clock, no right to organize under federal law. The National Labour Relations Act said domestic workers were not employees. The Fair Labour Standards Act said domestic workers were not workers. The Social Security Act, in its original form, said domestic workers were not entitled to retirement protection. Every major piece of New Deal labour legislation was written with an exemption that fell, with precision, on the industry where black women worked. That was not an accident, and it was not invisible to the women living inside it. What Dorothy Lee Bolden understood, from years of riding the bus across Atlanta, watching the women she knew get on and off in the same dark coats, carrying the same paper bags, was that the isolation was manufactured. These women were not alone. They were in the same industry, working in separate rooms. In 1968, she founded the National Domestic Workers Union of America in Atlanta. She organized on the city buses, the only place where the women who did this work were all in the same room at the same time. She had no office. She had bus fare and the understanding that the isolation had cost everyone long enough. The rule, the deepest, most load-bearing rule of this entire world, was that you did not organize, that you accepted the separation as the natural condition of the work. Dorothy Bolden decided the rule was wrong. 10 rules. 3 kinds of walls. The first kind was written, not always with domestic workers named, but aimed at them with precision. The NLRA excluded them. The FLSA excluded them. Social Security, in its first decade, excluded them. These laws shaped every rule on this list that involved hours, wages, and overtime. Changing this kind of rule required legislation. It came, but it came slowly. Social Security coverage was extended in 1950, and minimum wage coverage under the FLSA was finally extended to domestic workers in 1974, nearly 4 decades after the law was first written. The second kind was institutional, practices that employers chose, repeated, and standardized. The back door, the uniform, the unnamed worker, the expectation of invisible competence. These were not in any federal statute. They lived in an employer culture, transmitted from household to household through the same informal networks the workers used, but going in the other direction. This kind of rule changes faster than law. It doesn't require a vote. The trajectory here is real, but it is not complete. The third kind was unwritten and unspoken. Carry your troubles alone. Protect their secrets. Manage but do not discipline. Absorb the cost of the relationship in silence. These rules live the longest because there is no text to repeal and no employer to confront. They change only when the women doing the work find each other and agree that the cost has been high enough. Dorothy Bolden found the women on the bus. That was the beginning of the third wall coming down. Dorothy Lee Bolden worked in Atlanta households until she had worked in enough of them to understand that what she had been doing for 30 years was not a series of private arrangements. It was an industry, an unacknowledged, unprotected, unorganized industry, held together by women who had been kept separated from each other. One woman, one house, one family's secrets, one unnamed day. She died in 2005. The National Domestic Workers Alliance, the organization that grew from the movement she helped build, is still active today. The gap between what Dorothy Bolden's work cost and what it was worth runs through this entire story. She knew it. Every woman who rode that bus knew it. The next video in this series is about a different kind of work. Work done standing up, in your own space, with your name on the door. Next week, we look at the rules every 1950s black beautician followed, the unspoken codes of the beauty shop floor, the licensing battles, the clients who were really something else entirely. Subscribe if you want to be there when that one drops.